to second-degree felony offenses with caps of 10 years in each of those cases to run concurrently as the agreement. Is that correct?
Yes, Your Honor.
I've received the pre-sentence report as well as an update report that just has some more specific information from criminal history from Spokane, Washington. Did everyone get that?
Yes, Your Honor.
Yes, they did.
Are there any additions or corrections to the pre-sentence report?
None for this.
All right, Mr. Kimler, you may proceed.
Your Honor, PSI reflects extensive criminal history on Mr. Barbo, which I suppose the court could infer from the fact that two misdemeanor theft cases can be enhanced up to second degrees, which implies that he does have extensive history. The facts of these two cases are both, as the defendant indicated in the pre-sentence report, he was under the influence of methamphetamine at the time both were committed. It's not offered as a type of exculpatory evidence or even perhaps mitigation, but it does kind of explain why somebody with this criminal history would be doing what he's doing with a laundry basket and then some items from Walmart, all of which were under, I think, probably the Class B range of the theft. I would observe that there appears to be $300 in restitution payable on one of the cases for the laundry basket. Obviously, methamphetamine, drug addiction, but for that, I think Mr. Barbo wouldn't have been doing these types of boneheaded thefts. He's recognized that, and counseling with him, he's done at least what I asked him or suggested that he do, and that's to go into an inpatient rehabilitation program, drug rehab program, to try to address the substance abuse issues that he suffered from really an early age, which is indicated in the pre-sentence report. That's been an ongoing thing almost his whole life. And I think he's done that. And he's you could say terrified of going to prison, but certainly he doesn't want to go to prison. And I think he's willing to do what he needs to do to stay out of prison, to comply with any terms of probation that the court assesses. He indicates to me that he is drug-free, which obviously if he drug tested him this morning, that could be corroborated. Or not, if he's not drug-free this morning, I don't know. But I assume, I would hope that he is. And he would just like to address the court perhaps better than I'm more articulate to explain his position of why he thinks that probation is appropriate.
Are you wearing a drug patch?
No, ma'am. Your Honor, but I think the claims officer should nominate.
Have a seat in the jury box. Let's get that checked first. Okay, so the test was negative. Mr. Barbo, you wanted to say something, sir?
You could address the court.
Yes, sir. On this, Your Honor, probably an alcoholic drug addict my whole life. I went through treatment. I reached a point when this case came about, everything, my whole life, the futility of it all was overwhelming. And so anyway, so I've been cleaning so July the 8th. I go to AA regularly. I like it. It's where I belong. I've got a sponsor today. I'm walking these steps. I'm on step 4. Where I found a purpose I never had. And I think I could do well on probation. And hopefully one day save somebody else from live another day, you know what I'll live. Which is horrible addiction. Now that's all of that.
Thank you, sir. Mr. Coleman?
Judge, I'll be brief. I think the PSI speaks for itself as far as criminal history. I would like to add, I have judgments here. I've made them available to Mr. Kimler for additional convictions that were either not included in the PSI or they could not confirm those. And for the record, Judge, I am speaking of a 2013 aggravated assault out of St. Charles, Louisiana, in which the defendant received a 6-month probation. Also, a 2008 possession of a controlled substance case out of Kansas, in which the defendant was revoked to 20 months. And a 2013 fleeing or attempting to elude out of Kansas, for which the defendant received 5 days. I think that one is actually reflected in the PSI.
Okay.
The 5-day one.
Yes.
Also, Judge, I have judgments out of Spokane, Washington for 1, 2, 3 thefts The one from 2011, two of them, it looks like it was a concurrent 1-year probation in 2008, and also a 2008 assault out of Spokane, Washington, in which the defendant received 338 days. And I've marked them. I'm happy to offer them.
No objection.
I don't know that I need them. I've made the notes and we'll take that into consideration as
That's all
well.
I have. I think the defendant, given his criminal history, it's a risk of sounding callous, Judge. I get it. People are struggle with drug addiction all the time. But at a certain point, Judge, there comes a point where the consideration needs to be protected the public. This defendant's been having contact with law enforcement since 1988. And he has spanned at least 3 different states with his criminal behavior. Judge, he's fortunate to have a cap of 10. He's exposed to 20 years, Judge. I'm asking the court to sentence him to the few years.
4 different.
Guilty on that. I'm sorry.
Texas, Louisiana.
You're all right.
Yeah, it's yours.
Very sorry.
I'm so- Arkansas,
Tennessee, perfect.
Alabama,
So,
I guess my biggest issue, Mr. Barbo, is, well, one of the biggest issues is I appreciate and I'm glad that you have done what you've done over the last few months. I think you probably started off doing that for the wrong reason, and that's because you got caught again and you're looking at 20 years in prison. It sounds like maybe you're doing better, and that's great. I just wonder why it's taken so long. It looks like you went to the Unity House back in 1986, and other than that, it's just at some point you've got to take responsibility before you commit an offense, not after. I've counted 24 misdemeanors. I think with some of the ones that Mr. Coleman has said, there's probably actually more than that. There were some records that couldn't be found from different states. They're probably looking at more like 30. 7 felony convictions. You've been to prison. It's just too much. And at some point there has to be an end to what you're doing and get that help before you continue what you're doing. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 24, DCCR 1722, find sufficient evidence to find you guilty, and at this time find you guilty of theft, find your prior enhancement convictions true, sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 24, DCCR 2289, also find sufficient evidence to find you guilty, and at this time find you guilty of theft and find those prior enhancements true. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. I've handed you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices